All right, so it looks like I should be online. The problem is I don't know, because I just upgraded my phone, if I am on all of the media that I normally post on. So I'm going to start talking as if I am in hopes that I am, and if not, I apologize and see what I can do to clean up. So today is my weekly how-to series, and it is on how to collect and save information and evidence in a high conflict case. Now, this is not a video on how to present the evidence to the court. It's merely one how to collect it when you're out of court so that you have it later. I have other videos about how to present the evidence. I would or saying it's busy. All right, so my camera. All right, so it looks like I'm streaming. I'm just going to keep going. All right, so there's a few things you need to do about gathering proof in a high conflict case. The first is you always want as much of it in writing as possible. You don't want to get into a he said, she said, where you're claiming something happened, they're denying it happened, court has to look to body language and intonation. That's not good. So if you are in a high conflict case, you want to do everything you can to switch your method of communication with the other party to be writing. Obviously, emails are good, text messages, Google Calendar, so you can put in notes and print out the history. You can print out the calendar itself. Helps you also to refresh your recollection. A word on text messages, I'm not a big fan of text messages because they're hard to recreate. You know, you have 3 million text messages and you're getting screenshots of them, but it's better to have a text message in writing than to be forced to prove that something did occur because you don't have it in writing. So, like I said, so the first step is to make sure everything can be in writing or confirmed or proven by a document. Second is you want to have a way to record live evidence so that you get not only the other side, but you also, of course, can hear the intonation and what was really happening. Now, obviously, you can record audio and you can record video. When you're recording either one, first, if you're in New Jersey, which, by the way, I forgot to introduce all this when we started. So I'm in New Jersey. Today is Friday, 2014, February 14th. And my how-to video on collecting evidence. So this only relates to New Jersey. Forgot to say that. It only relates actually up until today's date because who knows what changes tomorrow. But so getting back to, it was just important because in New Jersey we are a one-party consent state, which means if one person in the conversation consents to being recorded, you can record it and that person would be you. Most states are one-party consent states, but there are many exceptions. So if you are not in New Jersey or you're recording somebody from New Jersey, but they're in a different state, you want to make sure that that state is a one-party recording state. Now, there is some issue with regard to recording, and that is a lot of judges will frown on certain recordings because they believe that you knowing that you're recording the other person, not that you're on your best behavior. You might be getting the person on his or her worst behavior. You also might be only getting a portion of the recording or the conversation and not the whole thing. Nonetheless, I still say you do it. Deal with the negative repercussions that come with it because it's much better to have something in a recording than to be proving it by testimony. So take the flack that you might get from it because the proof is much better. There's also an issue when it comes to tape recording or video of a child. First, I wouldn't record that child's conversation with another person unless it's something that you clearly believe the child is being harmed by, which the law in New Jersey is a little unsettled right now. That does suggest that you can record your child's conversation with another person if you believe the conversation is one of the nature that would be harmful to your child, but it's not well settled, so you have to be careful. You also cannot record any other person's conversation with another person. That's illegal, both state and federal offense. So you can only record your conversations, or your audio or video recordings must include you. But like I said, just keeping in mind, you will get some negativity. Judges are also very negative towards people who are recording their children. They don't want your children to be put in the middle of the issues or between their parents. But again, I still say do it. I'm putting this out on social media so the judges who know me will see my position. I'd rather you get flack from a judge that, and saying you shouldn't have done something, and have the hard proof that you need to establish what's important. Last is, once you have these things, you also need to know how you can prove or produce it to the court, how you can save and store it so that you can access it. Because if it's a high conflict case, you're gonna have a lot of issues, you're gonna have a lot of documents, a lot of recordings. You need to find a way to store it so that you can get it to the court. So the first thing I always tell people is to create a new email account. I usually recommend Gmail just because I use it for personal stuff and it's easy. And what you want to do inside of that is create sub inboxes. So you have a general inbox. Sometimes you'll have like a focused inbox, and Google or Gmail, for instance, has like social media and all those. You can create your own. So let's say, for instance, you have a high conflict custody case. You might want to create an inbox that says holiday parenting time. You might want to have one that says parenting time problems, one that says medical visits, extracurricular activities. So when you have an email or text message exchange regarding this topic, you can slide the email conversation into the box. You can even take your text message conversations, take a screenshot, forward them to yourself, and then store them in the internal inboxes, so that later when you have a case and an issue that comes up, you can go specifically to the inbox. You can print all the conversations on that one topic so that it's much faster and easier for you to establish your point instead of searching through 400 emails. If you have audio transcript or audio recordings, I usually recommend you transcribe them. Judges aren't necessarily going to sit for 30 minutes and listen to an audio recording. So there are the apps that I use that I usually recommend. I have no ownership interest in these companies whatsoever. I just think that they're very good. One is called Rev, R-E-V as in Victor. It's an iPhone app. I use the iPhone, so I don't know what other phones have. But Rev is a great one-touch recording app on your phone because it's one-touch recording, but it also will record in the background. So if you turn your face off on the phone, it's still recording and nobody can see. You can put the phone down on the table and nobody will know you're recording. You can also upload and have it transcribed for, I think it's $1 a minute. So it's nice to have the audio and the transcription. You attach it to the motion so that the court can read through the transcript. But you do also want to have the audio onto some kind of disc and provide it to the court and to your adversary, because they may want to listen to the actual audio. So you need to give both the transcription as well as the audio on a flash drive. You also can do the same kind of recording with your phone conversations with the same app, Rev. It just has a sister app that you use on your iPhone. It too will allow you to transcribe. It will allow you to upload and save into the internal inboxes that I'm suggesting you create with your email. I touched on the audio and videos. Again, you have to have a flash drive for that. And then lastly, whenever you have anything that is proof towards an issue of yours, you must provide it to the court in some kind of a document. You can't just walk into court one day with a bunch of text messages or emails, unless you have a trial, but then you would have provided it to the other side earlier. If you're filing a motion, if you're responding to a motion, even if you're going to like a case management or a settlement conference, always attach all of the proofs that you have, the audios, the videos, the calendars, the emails, to whatever document you're providing to the court beforehand. Because if you don't have it there, they're not going to accept it. So that, in a nutshell, is how you gather and collect evidence in a high conflict case. I would recommend you scan my YouTube page or website for other information about providing evidence to a court, preparing for trial and motion hearings and things like that. It'll supplement the information from today's video a great deal for you. If this information was helpful, I'd appreciate it if you give a like and share the video so that others get to see it. You can also subscribe to whatever medium you're seeing me on so that you get notices when I do go online, and you can message me through that platform. Any questions you have or any issues you'd like me to cover.